Hello classmate, my name is Jacqueline Arana. My presentation is on Chapter 9, Alternatives to Litigation from our textbook, California Real Estate Law by Hubbard and Taylor. In business contract, litigation is one way to resolve different types of disagreements when the parties encounter a conflict. California court judges require litigants to go through negotiation, mediation, or arbitration to avoid litigation. This saves judges time and taxpayer money. Chapter 9 discusses alternative dispute resolution and its advantage and disadvantage. Alternative dispute resolution is often faster, less expensive, and more human solution than litigation in a court. The first concept I learned in Chapter 9 is that legislature has found approaches to dispute resolution that are unnecessarily costly, time-consuming, and complex when achieved through formal court proceedings. Judges strongly encourage the parties to resolve the disputes outside the judicial process. There are costs and other potential advantages to alternative dispute resolution when comparing to litigation. Among these advantages are speedier, because sometimes it takes years before a dispute is heard by a court, less expensive because it takes less time and reduces expenses of resolving the conflict. Use an expert has the decision maker, and the parties can select the decision maker by agreement. Proceedings are confidential because they are private affairs and close to the public. The decisions are final and not appealable, and are less formal, where the parties determine how the process will run. The second concept I learned in Chapter 9 is an arbitration. The parties agree to submit the dispute to a neutral third party for a final and unless agreed by the parties binding decision. In arbitration, formal pleadings are not used. Discovery is normally quite limited. The rules of evidence do not apply, and should the parties so agree, the decision can be final and binding with no right to appeal the arbitrator's decision. This means that generally the arbitrator makes a final solution to the dispute. In this process, the parties are given up the rights to use the judicial system. Arbitration clauses should be knowingly executed and informed consent. California Code of Civil Procedure Section 1298 requires the contract for the sale of real estate and listing agreements title any clauses calling for the binding arbitration of disputes. For an arbitration clause to be valid in a real estate contract, the parties are agreed to initial the clause to show their willingness to arbitrate any disputes arising out of the contract. Moreover, a real estate agent must ensure the principal has been carefully read and understand the arbitration provision before initiating one. The third concept I learned is the integrative negotiation, basically win-win problem-solving situation, which occur when both parties win. This is a negotiation strategy in which the involved parties work together to find a solution that satisfies the needs and concerns of each party. The negotiators seek to achieve mutual gains and focus on the parties' needs and interests. It's something like I win, you win, is the purpose of integrated negotiation. In conclusion, judges look for alternatives to litigation to be solved outside the judicial process, which is time-consuming, expensive, exhaustive, and overwhelming. Before judges hear a case, California court judges routinely require litigants to go through negotiation, mediation, or arbitration. The Department of Real Estate and the California Real Estate use the Complaint Resolution Program, which has the mission to respond quickly and informally to concerns of consumers and members of the real estate industry by serving as facilitators to resolve conflict or to mitigate or prevent real estate law violations. This concludes my presentation. Thank you very much.